And where are we? I hate to.
So, tax sections on 520, CLC sections, for items they don't have any questions. We're supposed to come back out on the item 22 for reinspection. That's what we discussed at the pre-meeting. Is that you can tax on items, and then shall we here to discuss with the CLC. Nobody showed up on 22nd. Guys there waiting for the reinspection. Nobody showed up in the reinspection. So that's first and foremost. This point, not sure if we provided no notice to why they were not here on 22nd. We're expecting that too. So our guys are ready with items having been directed from the original list. Nobody comes to the show.
Anybody know why they didn't show up on the 22nd? Nobody standing from this with counsel.
Now, this is where bureaucracy meets reality. The defense says, we fixed everything, we're ready for inspection, but the city never showed up. In legal speak, that's a procedural breakdown. In regular speak, that's like studying all night for an exam, and the teacher just doesn't show. You can almost feel the judge's patience wearing thin.
I was in court, Jill and Meyer, and the were in court as well. He has other inspection factors, inspection center, we have guys ready. No, we got that they were not going to show up, and they know Joe before. What's here. There's no reason for them not to show up, provided because that they're not going to show up or to not arrange for other inspections to come to the property to stay. We should die.
So, I guess I want to make sure, maybe I'll call touch base and get something. She issuing an order
So,
laying out everything, because then I don't.
so Judge Kunky is presenting warrant. There's not much explained on the record. She will be entering warrant that appears to go property. Basically, urgently as possible, from, she will be presenting order with regards to tenant class or location, that nature. Obviously, we don't know exactly what it's saying, but rest. And as well as instructions to the city for timing of inspections, issues with that. So she's gonna require the city to inspect within 2 days of the request. And also, so.
Okay, pause right there, this is a crucial twist. Another judge, Judge Kunky, has overlapping jurisdiction over these same buildings. Translation? 2 judges, 1 problem. That's like having 2 captains steering the same ship in opposite directions. The court has to figure out who's actually in charge before anyone moves forward, and that's where things start to tangle.
Reasonably available for inspections if they're right on site or something. She's going to come more and be ready. So she's going to do her orders back.
Do we know when she's going to do that? Or is she in?
That we would possibly have a draft of that order at minimum, see what it looks like. She's waiting on 1 or 2 fits that myself and legal services are working on in connection with that. No, that's what we do about it, so I'm not sure.
Yeah, we're working on a solution level. End up to stay or if we fighting to send out for the list of yours that you send down. So we something, what she's dealing with in terms of focusing on repairs as well as how tenants might be locating this facility, from the external house, the city, as well as whatever they pay for the landlord, so that they can use that towards relocation for the tenants that are still in problem. All right, so what I guess I would want to make sure what's contained in that order. We have, this court has escrow bond.
Right. So one of the items that would be in that I think it's pretty much to do with the point is that Arbor One will not object to the release of the escrow, which is being held by the city or the court. We didn't see the requires that like all parties agree to some extent, so something of that nature. So the order will clearly say that.
This moment hits home for the tenants, literally. Escrow funds are money held by the court to protect renters while repairs are pending. If you're living in a building that failed inspections, that's your lifeline. The judge is making sure tenants can break their lease and move somewhere safe without losing their cash. It's not just law, it's people's lives and stability on the line.
They're elected and ready to break the lease and move from Arbor One, that we won't object to those funds being released, so we can utilize that to find whatever housing they want to buy.
Oh, so that will be contained in order.
Yes, that would be
Okay. So what it seems like to me, and I guess what I'm going to do is I'm going to pause. I'm going to try to reach out to Judge Kunky directly and just see exactly what she's doing, because she's going to assume all of this. There's no reason to court when you buy it from the jail.
to the extent that there are things on your document to located. So one of the things you indicate is those of you who are will pay half of the rent. I know that's something that
Pay half of their
what it would have been at Arbor One. So those having relocated, which you intend to come back to Arbor One. So temporarily relocating, so say, I want to come back to Arbor One once I replace the building with the CRC. Those folks aren't required to pay half of the rent of their home location.
I don't think that was part of this insurance. She did bring that up as also that feature. Bringing up these issues, tenants relocating themselves. Yeah, Mr. McGuire is relocated to the hotel. Since he's been to his apartment. Okay. So, I guess I'm curious. So where would, and I realize you don't have the order, where would this half rent be?
The Arbor One. So basically the argument was, if we're relocating to a place that has a CNC, whether it's, whatever accommodations are ultimately determined, the judge comes to me down and will see that she can have the rent. And so I believe it is going to be in part of the order. The last part we talk about no order, so there's no direction to relocate folks or something in the order that says folks can request and you recommend that. Yeah. So I believe that she decided that was going to be a part of the order. Yeah. And I bring it up, then it's something we talked about last time with folks that were on the document and going to establish whether or not to stay. At that point, we should decide with those folks, or if they're planning to come back to the seaside, that's the case that they're subject to that problem. So we just wanted to advise the court that it's something that we have to do.
Okay. So for individuals, I'm just thinking about the cases that are before. So for those individuals that relocated coming back, they would be, let's say their rent's $1,000. They would have to pay $500 to Arbor One. What happens? Okay. What happens with the other fees?
Which is the rent.
Yeah, it's just not paid.
I think that is a loss to Arbor One. I think the idea is that
Got it.
are safely everybody's staying. That was the,
yes. Got it. They pay half of their portion. What happens with the subsidy? I don't know if it's going to dress. Dress. Got it.
that was not something we got into.
Okay. So, I think what I will do is I'll make this.
Well, did you catch that? Tenants who are temporarily relocated still have to pay half their rent while out of their homes. That's one of those gray area rulings that sounds reasonable on paper but hits hard in real life. Imagine paying rent for a place you can't live in, just waiting for the city to sign off on safety. The tension between fairness and finance is palpable here.
Very short here. Because it seems to me that if she's going to do all of them, that I'm not going to do anything and wait and see how it affects the cases that are before me. With reference, so for example, just taking by way of example the escrow, that really, I think in some ways negates the escrow order, right? For those individuals that would fall within that class. Would you agree with that?
Change your escrow order.
Yeah, because so if an individual is intending upon coming back, what the South Dakota says is they need to pay half of their rent to Arbor One West. My order would indicate that they pay nothing if they have
Right, so yeah, you're not gonna give it engage that and then those sides even go together, they do that.
So of the cases that I have, how do I sort those out?
For those who have been relocated versus, so we don't know the extent of everyone's desire to be located or stay permanently or temporarily. Some folks are also found their housing at this point. So I think you would need to get a list of folks that have been located by Arbor One and, connect with them about if they intend on staying where they are or if they are intending to come from the city side. Staying where they are, then deal with visas. If they are intending on coming back to the city side, once the city the local county CFC, then we would be required to
Do we have any people still in Soul Center?
it's my understanding they're lucky still on. So we got to look somewhere.
Where are you? Springville, Tennessee.
On the city side? Inquire a little bit to what's going on here. Why that there, but why get this more information back to you?
Well, I just want to make sure that the 42 I have, that the orders that are consistent with what's been ordered. That's what I want to make sure. And I guess we can do that sort of on a continuum basis, or what I can do, and what I may be inclined to do, is to just issue a stay on these before me. And just await the final resolution. Okay. On the 9th of June.
You stay. We have some adjourn proceedings for say 3 weeks to see if we can sort everybody out. Who's going to do what? Then we can maybe look at some dismissals or CODs or settlement agreements in place.
Yeah. I'm not. That's fine with me also. I don't have a problem with it, as long as there's something kind of. It sounds like through what Judge Kunky is doing, kind of they can take it into account in terms of what's happening. So, still might work. I'm here a while. So it's worth fine. But once that's all small items, well, we choose that exist for all these things. Well, why don't I do this? Why don't I adjourn this out to? Why don't I adjourn it to the 27th of June at 12? All right. Allow that to kind of take place if necessary. And then, all right.
Thank you, Your Honor. And if you're getting to bring your staff out on the 28th, I have pamphlets showing a lot of
Thanks, comments.
So, what was your, problems? Next, next to go to the building, point, where, know, situations where nearly students are ready to go, I'm trying to meet ready. There are rating items on our short list, but not necessarily because we weren't corrected from the journalist, but upon inspection, so you can go for so we're obviously these major students are to kind of review it, where we are for that. We can go into ready for it. About to run COC, there's no reason that those should not be students. So correction order for now how items that need to be done. Please be provided a correction order and see that you're not seeing items overcorrected. The temporary COC provided order. At this point, we need those students that are ready to go.
But if you're coming to drive, the issuance of the temporary CEO.
We can talk about it. And stuff, it's been discussed. We see somewhere in the decline with insurance solutions inside. I don't use that much, you know. I don't think that we've run into explain to her that we would request a correction order items that, temporary COC in place, and that the correction order to something strong until those items are taken care of on the list. But no temporary COC was ordered by Kunky at the time. We also have those items. So we're going to be looking at information that there's no reason folks should be talking about items that folks recently moved out. One of the things we talked about at the meeting with the city was that, what do we do if we cannot find space when we move out, 5 days before? We're going to dig up, we're still trying to run in. A lot of these items are in support, in the most recent information are exact some of those and issues that are still waiting for inspectors to come out and inspect. Still have inspections set about. So these items are not things that you hold up a COC or a COC. These items can still be corrected, can be ongoing while those are in community soon.
Okay. So what I can do at this point is.
Here comes the big argument. The property's lawyer says, we've fixed everything. Let us open the doors. But the city's adding new violations every time they inspect. It's a legal ping-pong match. One side says ready, the other says not yet. The judge's upcoming decision could mean dozens of families move back home or stay displaced. What would you decide here?
We will cancel my 20 minutes. Should you given please be here. And I also given the fact that he's again don't want interfering with what certain courts that he's trying to do or trying to do something that might be inconsistent with I think it's going to cover sounds to me based upon what's being explained. It's just going to cover in the same way that I would the ones that he's before. Okay, thank you. So what I'll do is I'll adjourn this out to June 27th, 11 a.m. for a status conference. They should, yes, they should pay their escrow for June. And then, because as I understand it, given what that order circuit court may look like, depending on then what that tenant decides, there's going to be some disposition of that. Yeah.
Thank you.
The other aspect to it is, like, rather not funded, so we're able to restart the inspections. We still have that 65,000, I think, there's sitting here. That, I mean, the intent of that, as I'm recalling, was to pay the invoices of the city regarding some of these expenses. So, well, that was the problem before. You want that turned over to the city, but when we tried to do that, we were told that they didn't want us to take a lump sum. Right, but nobody knew what those were. And so, we had to
From our perspective, we would have no objection to claims being applied to inspection fees. I think that that's going to be this kind of hold up and some of these things done. I think that would help expedite, sure that things are done.
right, no. So, if anybody recalls the hearing, the sole reason that money ended up here is because there were inspection fees due, and then there was an indication that further inspections would be done, but others hadn't paid. Then I had to go through and try to figure out what the amount was that would be paid, and then I got a figure which was opposite of what I thought. I actually got a lower figure from the city than I did from Arbor One as to what was owed. So I took the higher figure, said put it in escrow, now it's there. When I also suggested that they just turned over the lump sum amount, that was sort of rebuffed because it was said, so I'm calling that they, who were here, don't like us to take it that way, that this will apply. So, I don't have a problem if the city were to get council get together while this is going on and come up with a...
Well, did you catch that? Tenants who are temporarily relocated still have to pay half their rent while out of their homes. That's one of those gray area rulings that sounds reasonable on paper but hits hard in real life. Imagine paying rent for a place you can't live in, just waiting for the city to sign off on safety. The tension between fairness and finance is palpable here.